All right, let's dive right into this explainer and demystify exactly how everyday citizens can hold judges accountable in South Carolina, and do it without getting completely lost in the legal maze. Look, the judiciary is supposed to be the cornerstone of our legal system, right? It's built on this premise that an independent, fair, and competent judge is going to interpret the law impartially. But what happens when that trust is broken? Historically, navigating the disciplinary system for judges here has been incredibly secretive and honestly super confusing for the general public. Well, today we're going to change that. We are looking directly at the rules, the strict processes you need to follow, and the recent push for transparency that's finally shedding new light on judicial conduct.
So here is our roadmap for today. Number 1, ethics versus legal errors. Number 2, the 5 judicial canons. Number 3, steps to file a complaint. Number 4, the investigation process. And finally, number 5, accountability and new transparency. Okay, kicking things off with Section 1, ethics versus legal errors, knowing when to appeal versus when to report. To start us off, we absolutely have to address the single most common mistake people make right out of the gate, filing an ethics complaint simply because you're frustrated by a judge's ruling. There is a hard, very limited line here, guys. If a judge simply misapplied the law, misunderstood the facts of your case, or made a ruling you strongly disagree with, that is a legal error. Your only recourse there is to file a notice of appeal within 30 days of the trial court's decision. That's where an appellate court steps in to review whether the law was correctly applied. But, and this is a big but, if a judge demonstrated personal bias, engaged in ex-parte communication, meaning, they secretly talked to one side without the other present, or showed severe intemperance, well, that is an ethical violation. You cannot appeal an ethical violation, and you absolutely cannot use the ethics board to overturn a bad legal ruling. Moving right along to Section 2, the 5 judicial canons, the ethical rulebook under Rule 501. So, what are the actual rules? Under Rule 501 of the South Carolina Appellate Court Rules, there are 5 strict canons of conduct, and these canons demand a highly elevated standard of behavior, both on and off the bench. Canons 1 and 2, they require judges to uphold integrity and avoid even the mere appearance of impropriety. This basically means a judge's conduct has to promote public confidence at all times. Now, Canon 3 is really where the day-to-day courtroom action happens, demanding patience, dignity, and absolute impartiality. Canon 4 dictates that a judge's outside life, their extrajudicial activities, cannot cast any doubt on their capacity to judge fairly. And finally, Canon 5 strictly prohibits inappropriate political activity, which is crucial for keeping the bench independent from partisan maneuvering. Now, you actually see these rules play out in the news during high-profile cases. Take a look at this real-world affidavit. It directly weaponizes Canon 3, demanding that a judge abstain from making public comments on a pending verdict. And this is exactly how attorneys and citizens use the rulebook to demand accountability in real time. When a judge's actions, like making statements about a verdict outside of a court order, come into question, it's these specific canons, like 3B9 or 3B10, that form the entire basis of a formal, strictly evaluated ethics complaint. Which brings us to a massive question: disqualification or recusal. Can a judge stay on a case if there's a conflict? Well, sometimes, through a process called remittal. If the judge discloses an economic interest or a familial relationship, and all parties agree on the record, the judge can actually stay on the case. But notice the absolute deal breakers here. There is zero waiving of actual personal bias or personal knowledge of disputed facts. In those cases, disqualification is mandatory. No exceptions. There is no remittal possible when a judge crosses those specific lines. All right, Section 3. Steps to file a complaint. The pragmatic playbook. If you ever find yourself suspecting a judge has crossed an ethical line, here is your highly actionable step-by-step playbook on what to do. First things first, put everything in writing. You don't need any magical forms you have to buy or download. A simple, signed letter will totally do. But listen, you must be laser specific. Under the new Rule 14 standards, complaints that lack specific details are just going to be immediately dismissed. You can't just say, the judge was unfair. You have to identify the judge, describe the exact act of misconduct, and ideally map it right back to the canons we just talked about. Attach your transcripts or court orders, and mail the whole shebang directly to the Office of Disciplinary Counsel, or ODC in Columbia. Section 4. The investigation process. What happens behind closed doors? So you drop that letter in the mail, what happens next? Your complaint enters a really rigorous screening process overseen by Disciplinary Counsel William M. Belich Jr. and his team. The very first hurdle is the if true test. The intake attorney basically reads your letter and asks, if everything in this letter is 100% true, did the judge actually violate the code of judicial conduct? If your complaint is secretly just complaining about a bad legal ruling, it fails the if true test right there and gets dismissed. But if it passes, the ODC opens a formal investigation. And from there, they don't just have to prove misconduct by a preponderance of the evidence. They have to prove it by clear and convincing evidence. That is a much higher standard, specifically used to protect the independence of the judiciary. Now, if the ODC does find evidence of a violation, the discipline can range anywhere from a private warning all the way to Supreme Court removal. For minor missteps, a judge might just receive a letter of caution. This is the mildest form of discipline. To give you an example, a recent transparency report revealed a rural magistrate received a letter of caution for engaging in administrative ex parte communication. Basically, because the magistrate lacked clerical staff, they communicated with one party about scheduling without promptly notifying the other side. It wasn't malicious at all, but it still technically violated Canon 3, so they got a written warning. Historically, one of the biggest criticisms of this whole system, and rightfully so, was that investigations could just drag on in secret for literally years, leaving a cloud over the judge and leaving the citizen completely in the dark. So, what's the solution? Well, to prevent these endless secret investigations, the South Carolina Supreme Court issued an order establishing a strict new timeline that takes effect in 2026. Under this new rule, if an investigation drags on past 450 days without any action, the judge can actually demand an investigative panel conduct a preliminary review. The ODC then has 30 days to report exactly what is causing the delay. It's literally a structural mechanism to force accountability within the accountability office itself. Pretty clever, right? And finally, Section 5, Accountability and New Transparency, Shedding Light on the System. As we've mentioned, historically, this entire system was incredibly secretive. Citizens had absolutely no way of knowing what happened when a judge was accused of misconduct. But thanks to intense journalistic pressure from outlets like Fitz News, the veil is finally lifting. The Supreme Court now requires the Disciplinary Council to publish quarterly summaries of every dismissed or privately resolved complaint. And looking at the inaugural data, you can really see why we focus so heavily on the difference between appeals and ethics complaints earlier. Look at this. 48 complaints out of this batch were dismissed immediately because citizens were trying to appeal a case rather than reporting an actual ethics violation. Another 15 failed simply because they lacked specific details. To put that into perspective, this proves that the vast majority of complaints fail not because of some grand cover-up, but because the public just doesn't understand the strict rules and the very limited circumstances for a valid complaint. So, as we wrap up this explainer, I really want to leave you with this question to chew on. Will these new quarterly transparency reports finally restore the public's full trust in the South Carolina judiciary? Bringing these previously secret disciplinary actions out of the shadows is a monumental step, for sure. But is transparency alone enough? By understanding the 5 canons, knowing the hard difference between a legal error and an ethical breach, and following the exact pragmatic steps to file a detailed complaint, you are no longer just a spectator in the legal system. You actually have the tools to hold the gavel accountable. Thank you so much for joining me for this explainer today, and remember, keep asking the tough questions.